Very good evening to all of you present here. I, Kapil Mehta, Assistant Professor, Anand Law College, warmly welcome you all on behalf of Anand Law College and Anand College of Legal Studies. Today's online session on Introduction of ADR has been organized in association with Center for International Alternative Dispute Resolution, that is CIADR. Alternative dispute resolution is the procedure for settling disputes without litigation, such as arbitration, mediation, negotiation, etc. If I talk about the organization, that is CIADR. CIADR is a global center of very high caliber for the profession and practice of alternative dispute resolution. It is the first and only dispute resolution institute, and if I say precisely, that is online dispute resolution institute in South Asia, which provides very natural, reliable, and cost-efficient dispute resolution services since 2018. CIDR renders a wide range of services, including networking, and there are other services like meetings, right, promotional opportunities, and other events in both online and offline modes. It also provides education and training for dispute resolvers such as conciliators, arbitrators, mediators, and adjudicators, independently and with collaboration with other renowned institutions as well. Now, I would like to invite Dr. Rekha Kumari Singh, in-charge Dean, Faculty of Law, SP University, and in-charge Principal, Anand College of Legal Studies, to welcome and introduce our today's guest, Ms. Hiranshi Shah. Over to you, ma'am.
Thank you so much, Kapil. Firstly, I would like to welcome our today's guest, Ms. Hiranshi Shah, President of YCI ADR. It is really honor for me to welcome on behalf of Anand Law College and Anand College of Legal Studies. If I have to introduce our speaker for today's session, Hiranshi Shah is Associate Member of Chartered Institute of Arbitrator, United Kingdom. Hiranshi is also a fellow member of World Mediation Organization. Apart from that, she is also international mediator and negotiator at CIADR and SAMA. She is also certified by Ministry of Corporate Affairs, Government of India. And yes, she is also a member at YSIAC, Singapore International Arbitration Center, and YAG, London Court of International Arbitration. We are really honored and privileged to have you. And yes, it is very important indeed. This topic is emerging, and indeed, considering that students should know, especially when it comes to online, that is alternative dispute resolution. So with this, I will hand over session to the expert session, not taking much of time. So over to you, Ms. Hiranshi. And we welcome you on behalf of Anand Law College and Anand College of Legal Study, both the organization. And looking forward for future association where our students should be part for more of like learning as well as exploring their potential.
Thank you so much, Rekhaji and Kapilji, for doing this and inviting me for this session. So yeah, so why as to we say that ADR, now ADR is so much important topic that we are like growing day by day, but till now we are not that much aware that what are the different forms are aware, what are the stages. So this is so much important as we are the litigation that ADR like have a aim to mainly to avoid the expenses delay, and also the main idea is to access to justice for all. So can you share the your screen?
Yes, ma'am. Good evening, ma'am. Sure.
Yeah, thank you.
Is it visible?
Yeah, it's visible. Can you animate next slide?
Yes, ma'am.
Yeah, thank you. Yeah, so basically, why this is ADR so much important. So as we all know that India is like cases are increasing day by day. There are like on till day there are we have around 40 million cases which are pending in across the Supreme Court, High Court, and all other subordinate courts. So therefore, we have a need to for provide a justice dispensation through other mechanism as to mainly eliminate the delay, speedy disposal, and also to reduce the cost and mainly to simplify the procedure. But we all if we have any dispute, we firstly think, okay, we are going the court and we solve the our dispute by litigation process. But there are also other mechanism which by through we can you can solve your dispute and also get the justice, and this is the ADR. So there are the mainly four mainly various forms of ADR, such as like mediation, conciliation, arbitration, lok adalat, negotiation, neutral evolution, and also some hybrid process as MEBAB, RMEB. So there are various form of ADR by which the peoples get solved their dispute and also get the justice through it. So next slide, please. Yeah, there are these are various forms. So what is the mediation first of all? So mediation is like process in which the impartial third party, which called as a mediator, will facilitate the resolution of dispute by using specialized negotiation communication techniques between the parties of the dispute and try to solve the dispute by amicable manner. Here mediator will only facilitate the communication and assist the party. Here mediator is not a judge and it is not an arbitrator, and the mediation process is all about voluntary process. The mediator can't force the parties as to settle the dispute, and also can't force to impose the settlement terms. The mediator have only control over the process of the mediation. So later that the process, so how this mediation will goes, as we in litigation we have a stages, as like firstly summons will be issued, then warrant, then reply, arguments, evidence. So there are all such as we have in mediation or other forms of ADR such as arbitration or conciliation, we have also some stages. So for mediation, the all process go in four stages. The first would be the introduction session, then second is the joint session, third is the separate session, and a fourth is closing session. So there are the mainly four stages of the mediation. So the basic objective of the first stage, that is the introduction and opening statement. So here the objective is to establish the neutrality, also to create the awareness and understanding about the process, and the develop the rapport with the party as to gain the confidence and the trust the party. So in this case, what the mediator do? So mediator firstly introduce himself to the party as, I am the Hiranshija, I am the mediator for today's mediation process. As then he explained the mediation process. As I said that for a mediation we have four stages as a process: joint introduction, joint session, separate session, and closure. Then he explained the role of the mediator, as the role is he is not a judge and he is not an arbitrator. He's only the facilitator who assists the parties in negotiation and they try to reach out the decision making between the parties. Here he also establishes neutrality, as like he declared that he has no connection with either of the party, and he has also not a interest not have any interest in the dispute. He also, the mediator also confirm the parties that they have a authority to present their negotiation and make a settlement, as it's not like any third party can on behalf like advocate can represent, but mainly think any other outsiders can't represent the case and attend the mediation process. So it is very necessary for the mediator to check the authority, as the person with who's beside him, he's an authority and he have a actual party of the case. And in that the mediator also like can establish some ground rules, as in like this is not a like as a court, the mediation like doing happen in the privately. So many times that happens, the both of party don't agree or don't want to cooperate each other, so they just make the allegations on each other, and so maybe happen that one of the party may be frustrated or like using like unauthorized like unconstitutional languages. So here the from the starting the mediator have to establish rules, as like if one person is speaking, then other may not not to interpret, and also as to language use maybe like in polite and respectful. So in while if mediation in during the mediation process, if any party like so much frustrated or using any such language, or if one party say, if one party said and don't interpret, and if even they, so the mediator can't say that are you in the beginning you are the agree with the ground rules, so stick to that. So in this so by this stage, it create the better environment which in that the negotiation and it motivate the parties for the amicable settlement, because the once they firstly they come, they don't know what is the process, how will this go on. Then second is joint session. So in this session, the main objective of this joint session is to gather the information and also provide the parties to hear the both the party, understand their perspectives, their relationship, what are the facts and what are the issues and what are the obstacles, and some like what are some possibility that by that the party can solve their disputes. So in this session, the in joint session, the mediator gathered the information about the factual background, that what are the facts of this case, and what are the and also he asked that what the concerns of the party, and also like try to interact with the party. So then it's for then is third stage is separate session. In that session, the main object of separate session is to understand the dispute at a deeper level. In it's like in the joint session, if one party have want to tell something, but he don't want to disclose in presence of other party, so in this session he can tell whatever, and here the mediator also reaffirm the confidentiality, as the mediation process itself confidential. How but the separate session is also confidential, that whatever party A will telling me during this separate session, I will not disclose to party B without the express consent of the party A. So here like it's also like we can say it's a double degree of the confidentiality, also the whole process and also for the separate session. So here the party can they disclose their confidential information that they don't want to share with the other party. He also like in that separate session, the main objective is to try to understand the interest of the party and to move the party for a solution finding, and encourage for to mutually acceptable some terms. So in this session when it's begin, so mediator explained explain their grievance and continue to gather information, and then he also like as I said said reaffirm the confidentiality. Then fourth stage is a closure. So in this case, like if settlement is arrived, then mediator will confirm the terms of the settlement and make and clear the complete and binding agreement. And if there is a no settlement, then in case if the if that case will be referred by the court. So mediator here just mention stating that the case is not settled, and he don't in his report he don't have to disclose that what are the reasons for that the case is not settled. So these are these four cases. Then is it second is the for mediation you have to also understand the what are the types of the mediation. So we have two types of the mediation: court referred mediation and the private mediation. So for the court referred mediation under section 89 of the CPC, the court have a power to refer the any disputes to the mediation center, even though in that so in the as per the Afcon judgment, which is the landmark judgment of pertaining to the mediation, and explained how to section 89 will be interpreted. So in that case the Supreme Court mentioned that without the even though none of the party agree for the mediation, court have a power to refer their case to the mediation if they think that this case have a element some elements of the settlement. However, we all know that actually it's not happen. Like we can compare that at least in month at least 500 cases is like institution in any court. When we compare to the statics as how much refer to the litigation, it's maybe just one or two, it's not more than that. So that's the thing that it's implement not as such implement due to some various reasons. Also in private we have also other types as a private mediation. In that it's a for a prelit. Then other form is a conciliation, is also one of the form of the ADR. It's like is a non-educatory dispute resolution process in which the neutral party is called as a conciliator, and he will helping the party to resolve the disputes. So here the what is the difference between the conciliator and mediator? Conciliator is just a facilitator. He can't impose the terms of settlements, or he even can't suggest what are the as to how to what terms of the settlement. Here the conciliator have a power to suggest the settlement terms to the parties for the resolving the disputes. So there is it creates some more as a some given more power to the conciliator. Then third form is the lok adalat. So in literal meaning, the lok adalat, we can say it's a court of the people, and it's also sometimes known as the people's festival of the justice. So here the lok adalat is established under the Legal Service Authority Act. So in that the mostly all of cases, even the compoundable cases, which are compoundable cases of the CRPs, also refer to the lok adalat. Here only the two types of cases which are not referred to the lok adalat, that is the divorce cases and criminal compoundable cases under the CRPC. They are not referred to the lok adalat, except the pre-litigation cases or any pending cases. Any pending cases in the court is referable to the lok adalat. Then next, yeah, there's the mediation. As I said, what are the stages, role of then the types, that the private mediation and the court annexed mediation. Next, I also discussed this is the process of the mediation, that introduction, joint session, separate session, and closure. Next, please. Yeah, this is the types of lok adalat types. So here there are the three types of the lok adalat. Three rather than say, we can say four types. The first is the national lok adalat. So the national lok adalats held regular interval, like as we say, within the 2 or 3 months of the and is held throughout the country, as to from the Supreme Court of India to the taluka level courts. Then is a permanent lok adalat. So the form is a permanent lok adalat. Here the permanent lok adalat is just organized for the public utility service and for the pre-litigation stage only. So here, the in permanent lok adalat, only the pre-litigation cases relating to the public utility services, that can file in the permanent lok adalat. So public, here public utility services, as mean the services relating to transport, or any like supply of the supply of the power, or any insurance services, they can refer their pre-litigation cases can refer to the permanent lok adalat. Here the permanent lok adalat is organized all working day except the Saturday Sunday. But in actual ground, in here, like in Gujarat, right now we don't have like permanent lok adalat is not organized in Gujarat, except the in Vishama is like the name of the permanent lok adalat, which organized at the High Court of the Gujarat. So in here the permanent lok adalat don't have a jurisdiction to accept the application pertaining to non-compoundable offences. And also we have here, it's mentioned the pecuniary the jurisdiction, as the the above the 10 lakh, if services, so the above the 10 lakh, it's not acceptable. Other form is also the mobile lok adalat. Here the lok adalat, it's travel from one location to another and to resolve the disputes. Then other one form is the MABE app. So it means the mediation and arbitration. Here we can say it is like hybrid form of the ADR. So here what is the here the where the dispute did not find, it's like it's not not settle and not get the solution in the mediation process, then the party may agree for the mediator that he may convert himself into the arbitrator and deliver his award. Why? Because the mediator can't, as we can say, like the mediator can't suggest the terms of the settlement, even he don't force to the parties. Whereas the arbitration is like adjudicated process, and here the arbitrator have a power to impose the terms and also to pass an award. So there is the thing. Then third form, sorry, fourth form is the negotiation. So the negotiation is, we can say, it's it involves the bargaining, and the how, like bargaining as to parties, as to set, like what the and come for one conclusions. So there are also some different styles of the negotiation. So as to we can say to uncertain, uncooperative, like some of the party uncooperative, or like in what we can say, if the participant in uncooperative, or we in side. So if the party don't uncooperate, we can identify it's not cooperative. So in that the participant do not cooperate the problem, what are the issues. So in that, so he we insist upon the interest, and to find out the some common interest, maybe they have both of party have some common interest. So find out it and bargain on that point. And in it also have a collaborative styles, in that the both party are very cooperative. So here they decide their own interest, both of party agree that this is our interest, and they actively understand the disputes, and may tell that what is the, yeah, hello. Hello, anyone have any question? Then the main thing that why we have to use the ADR as to resolve as a resolving the dispute and the get the justice, because that advantages. So mediation process itself the confidential. In here the parties have a control over the mediation in terms of their reference of the issue. The here in that case the mediator only to set the agenda as an issue, what to be issue, what should be the discuss. But what the identify the issue is made by the each of the party, and also the parties have a control over its outcome as to they want to settle or not. And also if they want to settle, so then what would be the settlement terms. Here the mediation is it's, if it is court annexed mediation, so the it is a binding and it's not appealable. And here and the law, in the case of the lok adalat, the award passed by the lok adalat is also binding, and it as per the legal service authority act, it consider as have a status of a decree of a civil court. So vis-a-vis it's like have a same same thing as it consider as a decree of a civil court. And like in every civil disputes the parties have to first pay the court fee. So in case like any pending in lok adalat, the pre-litigation cases and the post-litigation cases both are refundable. So in the post-litigation post pending pending cases, case is already pending in the court and the court referred to the court for the lok adalat. So here if the civil case, so they in the at the beginning they must pay the court fee. And in that case, if their case is solved in the lok adalat, then the court fee is also returnable to the parties. So this is also the benefit, as the court fees also returnable. Then it's the bindingness, and the main is confidentiality and control. So there are, we can say, the broad advantages of the ADR process, as the arbitration is a award passed by the arbitration is a also it's a also consider, and it's it's not challengeable except some circumstances under the arbitration and conciliation act. Conciliation, if the settlement is passed in the conciliation process, so it also not it's not challengeable and considered as a decree of a civil court. And for the mediation, so it's also have a same power. So that's like the main thing is why people have to opt this ADR method as to resolve the disputes and get the justice, because it's also speedy. For the mediation, there is a time limit as per the mediation rules 2003. So as per they have 60 days. So for the, we can say, just in 2 months or 2 months, the your if your case is settled, then and if not settled, then it will be it will go in the court of law. But if your case is settled, so you will get justice within 2 months only. So like we can't imagine that in 2 months you will get justice in a litigation process, because even the main also the thing that court have to follow the strict procedural laws. Here the in a mediation or conciliation or lok adalat, the it's not strictly follow the procedural laws. And the here the mediator also have. So there are main advantages of the ADR for the resolving the disputes. And as you if you if you know that I want to ask some questions to participants. So can you tell that as per that, what are the cases is solved through the ADR? What type of cases, as criminal, civil, labor disputes, consumer, environment issue, IBC, then insolvency cases, then RERA cases? I want answers from the participants. Then what you know, that what type of the cases solved through the ADR? May I have answer? You can also write in chat box. Am I audible? Hello?
Yes, ma'am, you are audible.
Yeah. Uh, so can we have answers from the participants that what type of cases solved through the ADR? Yeah, we get first answer civil cases. Yeah. You can also unmute your mic and reply.
Yes, ma'am. I think apart from criminal cases, we can solve all the civil cases through ADR.
Yeah, like civil cases, is compoundable criminal cases solved through ADR process?
Ma'am, heinous offenses are not compoundable. So yeah, if an offense is such that it is compoundable, so we may solve it.
Yeah. Apart from civil or criminal, the labor disputes or consumer disputes or IP dispute or insolvency disputes, or the banks also go under the surface. So that type of dispute is solved through the ADR. Like we have that any provisions in various acts. Does anyone knows?
Ma'am, we have a provision under IPC. I think section 89 of CPC. Sorry, CPC.
CPC, yeah, yeah, yeah. So apart from the CPC, what are the CPC? Then Arbitration and Conciliation Act, the mainly deal with the arbitration and the conciliation. Then mediation deal with mediation rules. Then Lok Adalat, it's seen to that the Legal Service Authority Act, composition of the NALSA, DLSA, and SALSA. So there is an under the Legal Service Authority Act. There is the hierarchy. The apex body is called as the NALSA, National Legal Service Authority. Under that, we have State Legal Service Authority, and in that the District Legal Service Authority, and the Taluka level, Taluka Legal Service Authority. So yeah, apart from this act, we have and like we don't have like only four act or CPC, IPC, and we can say Indian Evidence Act. There are lots of statutes. So is or like mentioning the word the mediation or arbitration or lok adalat or negotiation or any other form of the ADR. Anyone knows? Even you can also say like wrong, but at least you have to try that whatever. So we can also like interact. It's not just yeah. New York Convention. Which are the parties award either one? Okay. So New York Convention award. So here the in New York Convention, the arbitration and conciliation, our arbitration and conciliation act 1996, like made from the unilateral rules. So for the and in before that, it's also covered the New York Convention. We have a provisions under the New York Convention, and it is also the binding in the our court of law. The award is binding. As no one want to reply that what are the statutes, at least you can try so we can interact.
Students, please feel free to participate and reply, okay?
Okay, so no one maybe don't know or don't want to reply. So I want to say it's yeah CPC. I get one answer in chat box. CPC Arbitration Legal Service Authority Act. Yeah. Apart from that, the family we can say the broadly the category. Uh, so the for the family disputes, so that family dispute filed in the family courts. So the preamble of the family courts act itself the mention that the parties have to conciliate their dispute, and the court have a duty to resolve the dispute via the conciliation. So the family courts act preamble itself mentioning about the conciliation. Then the Hindu Marriage Act is also mention the specific word the mediation. That case would refer to the mediation. Also, the Special Marriage Act also mentioning the same. Then it's all about the family disputes. Then consumer disputes. So recently in 2020, the consumer mediation rule is passed. So in also the amendment made in 2019 in the Consumer Protection Act, and thereafter after the 1 year, the we have the mediation rules for the consumer cases. So here also the also it's made the pre-litigations as a pre-litigation stage, we can say, as like if any consumer want to file their case, so firstly that case for go for the mediation, and if it's not settled, then it will it will go in, in the consumer forum. So the consumer case is also settled through the mediation. Then the labor disputes, or we can say industrial disputes. So the main act, we can say, the Industrial Dispute Act. And we have also the we also have the Indian Relation Code 2020. However, it's not enforced till now, but it also have a provision of the conciliation. And for the Industrial Dispute Act, or we can say the industrial disputes, all industrial dispute firstly go in the go for the labor commissioner. So as we say, if like I am the laborer, or like I am the employee, or like I have any dispute, or I want to file the case in the labor court or in the labor court. So firstly I have to move to the labor commissioner. So and if so he and then if the case is not solved in the labor commissioner office, then the labor commissioner will refer the case to the to the labor court. It's not directly we can file we can file two or three categories disputes in the labor disputes directly to the labor court. But from apart from that, we have to firstly go to the labor commissioner office only. So here the labor commissioner, the assistant labor commissioner or deputy labor commissioner, they will act as a conciliator. As I said, that a conciliator have a power to impose the terms of settlement, and their award is also binding and also not challengeable. So via conciliation method, the labor commissioners try to solve the disputes. So here if we see then on a practical basis, so the mostly for the mediation or the conciliation, the all cases go stated as a non-starter. It means opponent party don't remain present. So here the main thing is it's all about voluntary process, that I want to come or not. So here the main thing is, if the once the party will agree to solve that dispute, so they will Great. Then after is like commercial cases. So in 2018, section 12A, 12A was the inserted in the Commercial Dispute Act, and it make the mandatory as a pre-institution mediation. So here, like any like any case pertaining, they have a commercial transaction, so they go in the commercial cases. So here is like on the pre mediate. So here the firstly the case, if party want to file the case under the for in the commercial court, so they firstly move to the district legal service authority as to file their case in the mediation center. And then after, the district legal service authority will send the notice to the opponent as to remain present. And if within 16 days, 60 days, as we can say, 2 months, if opponent don't reply, then the case will go to the court of law. So for the commercial disputes is also solved. Then then the civil cases. So the major act is a civil procedure code. So section 89 of the CPC, which state that settlement out of the court. So section 89 of the CPC mainly refer for they refer four form as to arbitration, then mediation, conciliation, and also for the judicial settlement. So for the as per the section 89 of the CPC, any case, any civil or criminal compoundable offense is referable to this any form of the ADR. So and here the what the procedure is, like court if as I state earlier, that if court find that this case have elements of settlement, they can refer the case to the mediation center or lok adalat, or for a conciliation, even without the consent of the party. But for the arbitration, so as we know, if any party want to settle their case in arbitration, so they must have a arbitration clause. But in arbitration clause, and then it will be solved then arbitration and conciliation act 1996 will be go. But in the section 89 of the CPC, what the main thing, or we can say differentiate between the thing, that even though party don't have a prior arbitration clause, which is necessary according to the arbitration and conciliation act, even though in that case both party mutually agreed and consulted, then the court can refer their case to the arbitration. And for the conciliation, the as per the section 89, both party consent is necessary, but for the judicial settlement or uh, a lok adalat or mediation without the consent of the party, court can refer. So the section 89 of the CPC mainly provide this that the settlement out of the court. Then also we have other provision as to order 10 rule 1A, which or 1B or 1C, we also talk about this as to how to interpret and follow the to procedure for the referring the case for the these forms. So that's the then for the maybe you have the for what you like you maybe confused that what will be the judicial settlement. So for the we can for the main thing is the definition of the conciliation, or definition of the mediation, or the definition of the judicial settlement is not written in any statutes. For the conciliation, the main act is the Arbitration and Conciliation Act. Even though the definition of the conciliation is did not written in that act. For the mediation, right now we don't have any act pertaining to the mediation. In India, we have mediation rules, and the mediation rules is made after the after the landmark judgment of the Salem Bar, and then after the in 2002, the Supreme Court directed to the made the committee, and then after the mediation rules are drafted, and it's submitted to the Supreme Court, and then after its direction would be given to the all high courts as to make their mediation rules in parallels with the draft which are submitted draft rules which are submitted to the Supreme Court of the India. So here the all states high courts have their different mediation rules, but they are the almost same. There is, we can say, all some minor changes in their mediation rules, but in somehow they they are the same. For the lok adalat, it's the thing. So there's the statutes. Then for the SURFACE Act, that under which the bank moved to the debt tribunal for to recover or attach the property and recover the money. So here the SURFACE Act also have a provision for the Arbitration and the Conciliation Act, as the party can refer their case for arbitration and conciliation. Then like it's for the, and even for the Negotiable Instrument Act, section 138, that check bounce. So in that case also, even pre-litigation stage, that as pre-litigation state, it means that case is still not filed in the court of law. So in that cases, the if case pertaining to those check bounce, so as per the section 138 of Negotiable Instrument Act, so it is also referable to the mediation. And and even the during the process, during the, so it court will refer to the respective their mediation centers. So it's also for the Negotiable Instrument Act, then Family Act, Consumer Act, then Labor Dispute, then what other disputes we have, Companies, yeah, Companies Act. The mainly excuse me, mainly did deal with the companies law companies. So in that section 442, which are inserted in 2016, which have a, which given the suo motu power to the tribunal as to refer the company's dispute to the mediation. And also in 2016, the separate companies mediation and conciliation rules are made. So for the companies, it express like we have the provisions for the mediation. So we can say that is that all type of dispute which like even the criminal compoundable offenses, yeah, non-compoundable offenses not solved through ADR, but apart from it, you can say in all other act, we have the we have provisions for the mediation or lok adalat or conciliation, which have expressly mentioned in that particular act. It's not just a three act which deal with the ADR, as we know, just Arbitration and Conciliation Act, Legal Service Authority Act, and mediation rules. But we also know that Hindu Marriage Act, Hindu Special Marriage Act, Family Courts Act, Companies Act, Industrial Dispute Act. So in each and every type of dispute, we have provisions of the ADR, but we don't use it because we don't have a knowledge about it. So the, as you are the students, you are the future lawyers, so you have to in the future think and make your vision to grow your career in ADR. As I said, the all type of disputes is solved through the various forms of ADR, and it's expressly mentioned the respective acts. So think accordingly, and try to adopt the ADR as a resolving the dispute and get the justice, and also encourage the people and aware them what are the about the various forms of the ADR. Thank you so much.
Okay, thank you so much, madam, for enlightening the students with your inputs and valuable knowledge. I hope that students will be definitely benefited from it. Now I would like to request coordinator of this event and assistant professor, Anand College of Legal Studies, Ms. Swara Anand, to present vote of thanks.
Thank you so much, Kapil sir. Am I audible?
Yes, ma'am. Yes.
Yes, ma'am.
Thank you so much, Kapil sir. A very a good evening to all of you. Just- I would firstly like to thank Anand Law College and Anand College of Legal Studies for giving me this opportunity to express my gratitude on this very special day to Miss Hiranshi Shah ma'am. Ma'am, with immense pleasure and gratitude, I would like to thank you for conducting such an interactive and wonderful session. Thank you so much, ma'am, for sharing your vast knowledge and experience related to ADR with all of us and our dear students. Ma'am, you have rightly explained us about the ADR, its various forms such as negotiation, conciliation, etc., and also for telling us about the benefits of Lok Adalat as well as the benefits we can access from the Legal Services Authorities Act. Ma'am, thank you for telling us about the various procedure related to ADR and various other laws except CPC, which are dealing with ADR. Ma'am, once again, I would like to thank you for sharing your information, and I hope that it will be helpful for our students in future as well. With that, ma'am, I would like to present a gratitude certificate to you. Ma'am, this is a gratitude certificate to you from both our institutions.
Thank you so much for your kind.
With that, I would also like to express my sincere thanks to our trustees of SRKSM. Without their support and effort, this function wouldn't have been carried out so smoothly. I would also like to express my sincere thanks to Dr. Amit Parmar sir, Principal Anand Law College. Thank you so much, sir, for your continuous support and guidance. I would also like to express my profound and heartfelt thanks to Dr. Rekha Kumari Singh, ma'am, in charge Dean Faculty of Law at Sardar Patel University and in charge Principal of Anand College of Legal Studies. Ma'am, without your bona fide and unaccounted efforts, nothing would have been possible, and this function would hadn't been carried out in such a soothing manner. I would also like to express my heartfelt gratitude to Ms. Megha Patel, member of YCIADR, for her constant support in coordinating this event successfully. I would also like to thank Mr. Kapil Mehta, sir, Assistant Professor of Law, for coordinating this event. I would also like to thank all the teaching and non-teaching staff of both the institutions for their constant support. My special thanks to our technical team, Mr. Akash Patel, Mr. Kamal Parikh, sir, Mr. Vedant Vyas. Last but not the least, I would like to thank all the participants for attending this session. Once again, my heartfelt thanks to all of you for for coming to this session. Thank you. Over to you, Kapil sir.
Thank you so much. Thank you so much, Swara ma'am, for such a wonderful vote of thanks. Uh, Now, before we leave, I would like to request all the participants that please stay connected. And I would like to request Dr. Rekha Kumari Singh ma'am to please share your message. Hello, Rekha ma'am, are you there?
I
Hello.
think
Yeah, maybe.
she's not audible. Let me check.
So, I would like to request our guest if she would like to leave the session. Yeah. Thank you so much, madam, for accepting our invitation. You may leave the session.
Thank you so much once again to Anand Law University and Anand Legal Studies to inviting me this session.
Okay, ma'am. It was our pleasure. Thank you so much. All the students are requested to leave the session after the guest leave the session. Okay.